Good morning to the folks out west, and good afternoon to everybody in Ontario or further east. Thanks to everyone for joining us today. I'm Stephanie Lewis. I am bilingual employment and labor counsel in our Ottawa office and a workplace investigator. And along with Cristina Wendel, who you will also be hearing from today, I am co-chair of our national workplace investigations practice group. Today, I have the privilege of being joined by, as mentioned, Cristina Wendel, a labor and employment partner from our Edmonton office and the co-chair of our National Workplace Investigations Practice Group, and Victoria Merritt, a senior labor and employment associate in our Vancouver office. As mentioned, Cristina Wendel is an Edmontonian, and her dedication to Edmonton pride is reflected in her undying support of the Edmonton Oilers in their pursuit of the Stanley Cup, as hopefully others are sharing that passion right now on this webinar, and she's so invested in their success. She's having nightmares about it. Last night, she had a nightmare that the NHL determined that the Oilers were going to start tomorrow's game with a penalty because a fan said something mean to the refs. Having survived the nightmare, Christine is now going to tell us whether or not we can claim privilege over workplace investigations. Over to you, Christina.
Thanks, Stephanie. It's true. So today, like Stephanie said, I'm going to be talking about some of the different types of the key types of privilege that are involved or have to do with workplace investigations. To put these into context, I'm going to be doing a bit of a case review of a recent case where Alberta case where the court went into a lot of detail about the different types of privilege. And then I'll just end with a few takeaways as well. So starting with just a brief review of the primary types of privilege in workplace investigations, and I'll go through these a little more detail in the context of the case discussion. But usually when we're talking about workplace investigations, we're talking about solicitor-client privilege, litigation privilege, and possibly statutory privilege in the OH&S context. So solicitor-client privilege applies to communications, which are firstly between a solicitor and client, second, given in the context of seeking or giving legal advice, and third, intended by the parties to be confidential. So this, as we'll see, is different from the litigation privilege, as the purpose of giving or seeking legal advice just has to be a purpose, not a main purpose. So shifting to litigation privilege, this one applies to records where the dominant purpose for their creation was at the time they were made for use in contemplated or pending litigation. So this is where you see the distinction with the solicitor-client privilege in terms of what the purpose is. The other piece I'll talk a little bit more about is note that it's the creation is where the analysis lies. And then the final category that will sometimes come up in workplace investigations is the statutory privilege. And now, because it is a statutory privilege, there will be some variations from one jurisdiction to another across Canada. So in Alberta, this is under Section 33 sub 8 of the Occupational Health and Safety Act, which provides that, so Section 33 is the section that sets out the mandatory investigation requirements where there's a serious workplace incident. So the employer, the prime contractor, as the case may be, has an obligation when there's a certain type of incident at the workplace to investigate and prepare an investigation report. So what Section 33 sub 8 of the Act does is it sets out that statutory privilege. So it provides that a report that is prepared in accordance with the Section 33 is not admissible in evidence really for any purpose. So whether it's in trial, in a public inquiry under the Fatality Inquiries Act, or any other action. So you can't admit that report in evidence. There is an exception if it's a perjury matter, but otherwise those reports are inadmissible. Next slide, please. So taking through some of these concepts in I guess, a real life example. I'm just going to be talking about the case of Prosser and Industrial Alliance Insurance. And so that was a case from the Alberta Court of King's Bench that came out last year. This was in the context of a wrongful dismissal action. The employee had been terminated for cause and sued the employer for wrongful dismissal. As part of the action, they had gone through some questioning, and the plaintiff had asked certain questions and made certain requests for records surrounding the investigation, and just basically asking for disclosure of records that related to the defendant's decision to terminate. The key records in question were records that had been obtained by a human resources consultant retained as an investigator to investigate harassment allegations that had been made against the plaintiff. The defendant had refused to produce those records, and it claimed both solicitor-client and litigation privilege as attaching to those records. Next slide, please. So almost immediately after the defendant received the harassment allegations, it started an internal investigation, and it also retained legal counsel to provide it with some advice about how to deal with the allegations. However, shortly after that happened, one of the complainants issued a demand letter. So the next day, the defendant retained an external human resources consultant to conduct an external investigation. And from the evidence, it sounds like they pretty much put their internal investigation, set that one aside, and then proceeded forward with the external investigation. The investigation was concluded over the course of a few weeks, and then about 3 weeks after that, the defendant terminated the plaintiff for cause. And just one note that proved to be important in a later component of the decision, the defendant relied on the investigation in its pleadings and its statement of defense as to justify how or why it had just cause to terminate. Next slide, please. So going back to what the plaintiff was looking for, so he was looking for disclosure of certain parts of the investigation file. So that included things like transcripts, notes, recordings from interviews, as well as information details about those allegations. There was also a request for to identify one of the complainants. So one, I believe, had been identified, but the second one had not been identified to the plaintiff. So the interesting piece is the plaintiff wasn't looking for the investigation report. Now that may be that it accepted that that one was subject to privilege, and I'll talk a little bit more about the distinction between the report and the rest of the investigation materials, but really it was the other part. So it was the investigation file, but not the report that the plaintiff was looking for in this. So the issues for the court were firstly whether the records and the information were privileged, and then secondly, whether the defendant waived privilege by pleading matters concerning the external investigation in its statement of defense. Next slide, please. So in its review of the issues, the court conducted a very thorough analysis and review of earlier cases that have looked at and developed the concepts of solicitor-client privilege and litigation privilege. So starting with what the court said about solicitor-client privilege, some of the key points are solicitor-client privilege does not have to be in contemplation of litigation, so that's not part of the test for the solicitor-client privilege. But it is important to note that it's not every form, it's not every communication or email or letter that's between a solicitor and client that's going to be covered by the privilege. So for example, you can't just copy your lawyer on a communication that isn't itself privileged, that doesn't involve legal advice, and then try to use that to claim the privilege. So the privilege attaches only to communications that are designed to seek out or give legal advice. And that's the key component of that test. So where things get trickier is where, for example, a lawyer is retained to conduct a factual investigation or provide non-legal advice. Typically in those situations, the communications will not be subject to the solicitor-client privilege because, again, there's no component of seeking out or giving legal advice in that. It's strictly a factual investigation or non-legal advice. When we're talking about third-party investigations, where one of the purposes of the investigation is to learn facts to then give to the client's lawyer for legal advice, then it may be in those instances that the investigation file, is going to be subject to solicitor-client privilege. So it doesn't, so it can also extend to third parties, where those third parties are essentially acting as intermediaries between the client and the solicitor to enable the lawyer to provide that legal advice. So the question then is whether the investigation was related to the delivery of legal services. Next slide. When we look at litigation privilege, again, it's the dominant purpose test that you look at for litigation privilege. And the focus there is what is the purpose for which the records were prepared or created? Again, not the purpose for which they were obtained. So for instance, with pre-existing records, they're not automatically going to fall under litigation privilege just because they then become part of the investigation file. It's not a blanket privilege. It is something that has to be determined in a record-by-record assessment. So in some instances, for example, you'll get an investigation report, and the report includes a number of attachments. It might have pictures, statements, policies. Just by virtue of attaching it to a report, even where the report is privileged, does not necessarily attach to all of the documents that were included with that. And it's not to say that you have to look at it on a page-by-page analysis. You can also group items. So for instance, if you have a number of pictures that form part of an investigation file, you don't necessarily have to go through on a picture-by-picture basis, but you look at the pictures in context. What was the purpose for which the pictures were created? So if the pictures were created for the purposes of the investigation, then it's easier to claim privilege. But if the pictures were already in existence when the privileged investigation started and were gathered as part of the investigation, then they're likely not going to be covered by the privilege because, again, it's when they were prepared or created that is key. Another example that comes up from time to time is employee statements. So if the privileged investigation, if the investigator asked employees to provide statements in the context of the privileged investigation, then those statements will likely be covered by the privilege. However, if what the investigator did is collect and include employee statements that had already been provided, so for instance, some employers just have a standard policy where there's an incident, they'll ask their employees involved or witnesses to provide statements, and then those may form part of the litigation privileged investigation file, but does not necessarily turn them into privileged records just because they're included in that. Again, it's the question of the purpose for which the records were prepared or created that has to be analyzed. Next slide, please. So in this case, the defendant had a few arguments and put in a couple of affidavits. Again, this wasn't a trial. This was in an interlocutory application where the question was just the production of these records. So the defendant was arguing that the investigation information was assembled by the investigator for the purpose of providing it to the defendant's lawyers to enable them to provide accurate legal advice. So that was the basis for claiming the solicitor-client privilege. The defendant also argued that the records were created for the dominant purpose of anticipated litigation. The problem is that's not exactly what the evidence said, and ultimately that's where the court's decision turned. So like I said, the defendant had included a couple of affidavits in support of its position. The first affidavit stated that the investigation was conducted in accordance with the respectful workplace policy and the defendant's obligations to its employees to ensure a safe workplace. It did discuss the report, and it specifically stated that the report was provided for the purposes of obtaining legal advice, but it didn't include any information specifying about what the purpose of the rest of the investigation file was, other than that point there, that it was pursuant to the policy and the defendant's obligations to ensure a safe workplace. The defendant had also provided a second affidavit, but in that affidavit stated that the defendant had started the internal investigation under the policy, but then shifted to the external investigation with the sole purpose to prepare for litigation and obtain legal advice. So here they're saying that the primary purpose of the investigation was to inform the legal advice that was being provided by the defendant's lawyers about potential litigation. Again, remember that they had received that demand letter from one of the complainants. Next slide, please. So while the defendant was arguing that the investigation information was both subject to solicitor-client and litigation privilege, the court was troubled by the conflicts in the affidavits and ultimately held that the defendant had not met the onus. So the onus in proving that the records, the information is privileged, is on the party asserting the privilege. So in this case, that was the defendant. And the court found that the defendant had just not successfully established that. The court looked at the initial affidavit. The purpose of the investigation there was not stated to be to obtain legal advice. It was to discharge the obligations under the policy. Again, that first affidavit did not mention the investigation as a whole. It referred only to the investigation report as potentially being subject to privilege. And again, that may explain why the plaintiff wasn't trying to get production of the investigation report. The court also commented on the policy itself, noting that it served a very important function. So it's not something that can be like the court said, lightly assumed to be an unimportant operational process. It was a key important process for which the investigation was stated as having been commenced to serve that purpose. So ultimately, the court found the affidavits did not establish the dominant purpose for creating the records and acquiring the information. So it was not prepared to assume that that was done in contemplation of litigation. Next slide, please. As noted, the evidence did show about the report was privileged, so the court stated it was probably subject to privilege. Again, it didn't need to decide that because it hadn't been requested. The court also commented that if it had found the records privileged, it would have found that the privilege had been waived. And then again, that stems back to the statement of defense. So the defendant had included a number of comments in its statement of defense relying on the report to form the basis of its defense. And the court there found that that constituted a waiver of the privilege had it existed. So just to wrap up with some takeaways, next slide, please. So employers should just assume that investigation materials are not automatically going to be considered privilege. Keep that in mind when conducting an investigation, when engaging counsel or a third party to an external investigator to conduct an investigation. Don't assume it's going to be subject to privilege. And for that reason, as the investigator, don't promise complete confidentiality to the witnesses that you're interviewing. Keep in mind, engaging counsel, just because you have a lawyer as your investigator does not automatically make it privileged. If you are concerned about having a privileged investigation, but you also have an obligation to investigate under the policy or the statute, if it's an OHS incident, you may want to consider having separate investigations. The purpose of the investigation should be made clear at the outset. So if the employer is wanting to assert privilege over the investigation, it should set that out in the engagement with the investigator. So clearly state that the purpose is to gather or to provide legal advice if it's a lawyer, or to provide information to the lawyer to provide legal advice. Mark your privileged materials as privileged. Again, that's not going to be determinative, but you do want to make that clear where you're asserting the privilege, that it is marked on those documents. And then that kind of ties into the next point, which should alert people that this is something they shouldn't just forward around to everyone. So you do have to make sure that you limit access, you limit who has it, because you can inadvertently waive it if you're spreading the information or the report, for instance, too widely. And then just the last piece is just to exercise caution when drafting pleadings so that you don't end up in the situation the defendant in the Prosser case did, where they were found to have basically waived the privilege had it attached. And so with that, I will turn it back to Stephanie. I do just want to make a note, Stephanie, Victoria and I want to make sure that you give yourself a fun fact as well.
I'm gonna have to start thinking about it now in real time, because in the interim, thanks very much, Cristina, for that excellent advice. We're going to be talking a bit more about lawyer-client relationships in the context of investigations in my presentation, which will apparently follow an interesting fact. But in the meantime, we're going to hear from Victoria Merritt, an excellent senior associate in our Vancouver office. And Victoria's interesting fact, which I love to death, is that she grew up in Yellowknife, Northwest Territories, and her first job when she was 11 was feeding sled dogs. Anyone who can look out for sled dogs has increased credibility in my view. And with that, Victoria is going to tell us about assessing credibility in workplace investigations.
Thanks very much for that introduction, Stephanie, and good morning or afternoon, everyone, depending where you are. So we are going to talk about assessing credibility, which is a very challenging but important part of most investigations. Interesting, when we were discussing the content for this presentation, Stephanie said, "Oh, I love credibility assessments." And Cristina and I went, "Oh, really?" So I think it will depend on the investigator how they feel about having to assess credibility. And to follow a similar structure that Cristina did for her section, I'll be opening with some basic principles. I'll then talk about how those worked out in some recent cases that are quite interesting and I think helpful to kind of illustrate what those look like in practice. And I will close with some additional tips. I apologize, I might be a bit coffee this morning. It's a bit smoky where I am, but I think it will also force me to speak slower, which if you've attended webinars with me before, you know is sometimes a challenge. So in terms of sort of the basic principles, so credibility does not always have to be assessed. It often does, and anytime there's sort of material conflicts in the evidence that you have to resolve to make your findings, you're likely going to have to do a credibility assessment. Sometimes there are no concerns with the credibility of the witnesses. Everyone's honest. There's great documentary evidence, for example, or maybe the parties all agree on what happened, and what you're really deciding is, you know, okay, did this discussion that everyone's story is very consistent on cross the line into bullying and harassment, for example. So there are circumstances where you may not have to make a full credibility assessment. We would always recommend, you know, in a report, you kind of address, if you haven't, why not? Or if it was that there were no credibility concerns, you do that. The other piece is your credibility assessment's not a blanket. This person is credible and I believed everything they said. This witness, I'm not credible, didn't believe anything, or this party. So you can accept some, all, or none of a witness's evidence. You can prefer conflicting evidence of one witness or over another, but you can do that in a very allegation-specific way. And we'll see some of the cases that I'll talk about are a good example of sort of breaking down the credibility assessment into a more manageable piece. There's also a distinction between honesty versus reliability. There's some inconsistency between different decision makers, how they talk about it. I think from an investigation standpoint, thinking of your credibility assessment as including both kind of, you know, how reliable is this person's evidence, and do I think they're being honest? So you can, of course, have a witness who is honest, but not reliable. So example on the slide, you have no concerns that they're answering the questions honestly, but they don't seem to have a great memory. And so you're not necessarily going to put as much weight on their evidence as you would in another witness who actually, you know, took contemporaneous notes and has a very detailed recollection. It is just very organized in terms of how they remember what happened. Reliability is also influenced by things such as, you know, oh, you were super far away. So, you know, I hear you saying, wait, you're genuine in terms of what you're telling me you saw, but I have some concerns about your ability to actually see that in so much detail. And that's often the case with what I call very helpful witnesses. So they want to help, they want to share information, but maybe it's not reliable. So I think considering both of those factors is important. So if we flip to the next slide, this is the golden rule. Lawyers love citing old case law. So I don't even know how many times Verna and Shorney has been cited in both case law, arbitration decisions, human rights, and investigation reports. But this quote is kind of the golden rule for credibility assessment. So in short, the real test of the truth of a story of a witness in such a case must be its harmony with the preponderance of the probabilities which a practical and informed person would readily recognize as reasonable in that place and in those conditions. What does that actually mean? And there's a lot of decisions that try and unpack that and help people actually do a credibility assessment in practice, which is obviously much more challenging than just quoting this in the decision and then saying someone's credible or not. So one of the things to take away from this is, reasonable in that place and in those conditions. That's the context is key. But if you go on to the next slide, here is a list of some of the key factors that are actually included in a credibility assessment. And so we'll touch on these and then you'll see them get unpacked a bit in the decisions and also in my final slide, which is some more practical suggestions on how to work through a credibility assessment. So one is capacity and opportunity of the witness to observe the events at issue. This is going back to the reliability piece. Had they been 5 beers in when they thought they saw this altercation between coworkers? Were their vision's actually really bad and they'd forgotten their glasses that day, so they can kind of see the mobile equipment, but not really. The second piece is, of course, ability to remember those events. I'll touch on this more at the end, but I'd caution if you're dealing with somebody who typically a complainant with a traumatic event, that can have an impact on ability to remember. So can time. So this factor, I would say, is needs to be considered in the context of when this person's telling you. If they're talking about something that happened 2 years ago, they're probably going to be a little fuzzy. That's not necessarily any indication that they're credible or even that they're not reliable. If they're talking about something that supposedly happened yesterday, that might be a different story. The third piece, ability of the witness to resist being influenced by their interest in recalling those events. So this is motive. So, you're best friends with the respondent, you're super close, you open the interview. This witness opens the interview by saying how offended they were to learn that these allegations had been made. Clearly there is a little bit of a temptation for that particular witness to downplay what they saw or how their best friend, maybe behaved. So again, just a factor, but those are the sort of things that you're going to be keeping in mind. Internal and external inconsistencies. This is a really critical one. So internal inconsistency is, the witness did a statement at the time, and now in their interview, they're suddenly changing their tune. Or even within the interview, they told you something in the beginning, and now that is very different than what they're kind of closing with. Those are definitely always important to flag. And again, thinking through why those inconsistencies are there matters. External inconsistency is this person said something and the document says something completely different. And as kind of a big picture thing for credibility, it's important to consider what the inconsistency is on. So if it's a fact like a date, people honestly might make a mistake about a date. If it's, did this person call somebody a derogatory slur, that inconsistency is going to be much more material. Admissions against one's own interests, this would typically be, you a respondent, and this does sometimes happen, who is very candid. Yes, I did I did that. I said those things, but I didn't say X, Y, Z. So again, it's not that anytime somebody makes an admission against their own interest, they're credible, but it's certainly something to consider in the big picture when you're doing your credibility assessment. This last piece is kind of really, does it make sense with other evidence? And doesn't line up with other really reliable and good evidence, like video footage, right? And then the final one is, does their evidence seem unreasonable, improbable, or unlikely? So somebody who has an incredibly detailed recollection of something that happened 5 years ago, and they're able to share, and they have no notes, they weren't actually directly involved, and they're just going on with incredible detail. That might be a bit odd, or they're saying things that just make zero sense in the context of what else you know. So if we can go to the next slide. We'll just discuss a few of these in a recent human rights case decision. This is also an interesting decision because it illustrates the huge delays we're having in our human rights process here in BC, which some of you have had to deal with. So this case concerned events that occurred in 2019, and the events all related to alleged racial harassment at work. The hearing was in 2023, so 4 years after the events had actually happened. And the decision came out in 2025. And prior to this hearing, one of the key witnesses, and really the respondent, this Mr. Ross, had actually passed away. So he was not able to give evidence at the hearing, so they had to go back and try and weigh kind of what he had said at the time. And the key issue was whether Mr. Ross had used the N-word repeatedly in the workplace, and there were also some other allegations, including a physical altercation. So this case is a good example of kind of working through a credibility assessment on an allegation by allegation basis. So these quotes are from the decision, because the parties fundamentally disagree on the facts. This case turns in large part on the credibility of the witness's evidence. The complainant said the N-word was used. The respondent and employer witnesses said, no, it was not. Very clear conflict, essential to resolve. Ultimately, and again, this is an allegation by allegation specific assessment as well, but the complainant's version of events was generally found to be consistent with the contemporaneous documentary evidence. So contemporaneous documentary evidence like notes or witness statements from the day after are obviously typically going to be given a fair amount of weight. This is not a factor when you're actually doing the investigation. So of course, some of these cases, are not as relevant for the work an investigator does. And in terms of the two allegations, so this case I wanted to touch on because it goes back to one of those credibility assessments, which is the inability to recall information. So one of the things the respondent argued was that the complainant and the witnesses' evidence was not credible or less credible because they gave inconsistent evidence about how they had ended up providing witness statements. The decision maker rejected that made them less credible because they found, fading memories of events that occurred 4 years ago earlier is to be expected. And then the second piece is important. So why and how they provided their written statements is a detail that doesn't really impact the central issue, which is whether the individual in question made the comments they said he did. So the fact that they couldn't remember, when they were asked, when they put their statements in, how many complaints there were, none of that was really super relevant or material. And so the fact there were some inconsistencies on that did not sway. Oh, I see I'm running out of time. Thanks, Stephanie. If we move to the next slide here. This is another one, again, it doesn't come up so much when you're doing an investigation because at that point you're probably not going to have a witness statement, but this was an inconsistency in terms of the initial reporting versus reporting in a human rights complaint, so at the actual hearing. And again, the respondent said, hey, the complainant didn't actually put that Mr. Ross had used the N-word in his witness statement when he talked about this physical altercation. But now he says it was used. And this was a second allegation. So this employee said, it's fine, or the decision maker, apologies, said, I understand in context why that wasn't made. And that's set out on this slide, that analysis. So we go to the next slide. So this case is another actually very serious allegation of racial slurs. And I've titled it What Happened in the Lunchroom, because like many investigations, this really turned on kind of one series of events that a number of people witnessed and had different opinions on. The griever had been suspended and ultimately dismissed due to an investigation into inappropriate conduct in the workplace, and he grieved the dismissal. This complaint was based on racist comments. You can see them on the slides. They're very egregious. Several different witnesses gave evidence about what they'd heard the griever say in the lunchroom. The griever denied saying anything racist, or in fact anything at all, to the group in the lunchroom. He just kind of come in, they were already having a discussion, and he kind of gave what I'd call kind of a classic respondent narrative sometimes, which is, this is a witch hunt. These guys are all out to get me. They colluded. So again, the griever's evidence directly contradicted the witness's evidence, so there had to be a determination as to who was credible. So if you go to the next slide. Again, this is a nice paragraph summarizing some of the factors we've talked about. So one of the crucial determinations is, was there any motive for them to falsely accuse the griever? So the griever attempted to suggest that one of the witnesses was the architect of a witch hunt and had orchestrated the evidence of the other witnesses. And then the griever conceded, well, I don't have any actual evidence to support that. And the arbitrator said, well, actually, the evidence showed that you had a very civil working relationship, and there were some text messages, and both of the individuals spoke reasonably positively of one another. So that completely contradicted any motive for that individual to be out to get the griever. All four of the employer witnesses were found to be credible. They gave clear, compelling evidence. Their testimony was internally consistent, so consistent with the interviews they provided at the time of the initial investigation. There were some minor variations in terms of what happened, but overall, their narratives lined up. And the stuff they did afterwards, or just with respect to this worker generally, supported their testimony. And then if we go to the next slide. This is important. So the decision maker says the evidence of the witnesses was not perfect. But again, this is back to our previous point, none of these differences were substantive or impacted the significance of what they witnessed. In fact, the slight inconsistencies completely undermine the assertion that they were colluding. And then slight variations in the evidence of witnesses is to be expected as people perceive and filter their experience through their own lens. So again, very important that, a minor inconsistency isn't the end all and be all. We go to the next slide. This is just the final piece in terms of wrapping up the credibility assessment. So I'll leave that with you to look at. If you go to the final slide, a few final tips. So use caution when considering personal demeanor. So by that, I mean, you don't want to have something like, oh, I thought this person looked sketchy, right? That's not personal demeanor. Personal demeanor would be something like the complainant says that they never yell and they never swear. And then in your interview, the complainant yells, I can't believe they often did this. Make sure you're informed on the impacts of trauma on recall and also myths and stereotypes, particularly important for sexual harassment complaints. Again, it's not a vibes check, to use youthful slang. You have to be able to explain how and why you reach your conclusions. If you're assessing the credibility of any party, you should assess both. So if you find the respondent not credible, you also need to explain why you found the complainant credible or more credible. Failing to review all the relevant factors, look at it big picture. Making a blanket credibility assessment, so just determining at the outset someone's credible, someone's not. And of course, be careful for unconscious bias. And with that, Stephanie, I will turn it back over for you to introduce yourself and share your fun fact.
Hello, friends. Well, thank you very much for that, Victoria. I do love a credibility assessment, which is not my fun fact. My fun fact is that I love crime procedurals. I'm so addicted to them. I'm low-grade addicted to Law and Order Criminal Intent Toronto. And when we had a national employment group meeting in Toronto, and I went to get something, I went to get a snack in the path, and I passed by the Shoppers Drug Mart that I'm pretty sure is the Shoppers Drug Mart that appeared in like the second episode. I was overcome. I was verklempt. I was like, oh my gosh, guys, that was in Law and Order Criminal Intent Toronto. So that is my interesting, not so interesting fact. And I'm going to tell you today about some procedural fairness updates from Ontario and Quebec. Next slide, please. So in 2024, there were two new decisions that rocked the world of workplace investigations. The Toronto Metropolitan Faculty Association and TMU decision in Ontario, an Ontario labor decision, and the Syndicat Personnel Enseignant du Campus de Saint-Laurent. The full name and the site is there. And so we're going to go into these in a bit more detail, but what I want you to ask yourself at the end of the day, while these are compelling stories, is this really new? Is this really new information? Next slide, please. So the TMU decision, as I mentioned, is an Ontario arbitral decision with a number of ongoing investigations, and there are issues with retainers and timing, services rendered, and a really unhappy faculty association. I should note there are people on this webinar who know more about this decision than I do, and I am happy to be told updates or different information in the event that what I've gleaned from the case law is not the full story, which is always the case, right? But you never know what's happening. But the stories on the investigations, we're going to start with the background of the investigation so you know how we get where we're going. First investigation, a prof makes a complaint to the university's Human Rights Services Department alleging discrimination on March 8th. Now, the next update in the case is that a retainer, so there's an internal assessment that happens at TMU, and then it gets sent to an external investigator. The retainer with the external investigator is signed on June 2nd of that year. There's 3 months that happen in between. So for the people who are employed by federally regulated employers, and you're thinking, 3 months, that must be nice. Like federally regulated employers have to get back to the complainant within 7 days. We know there are strict things defined. So the retainer is June 2nd. Then, and the retainer talks about 2 stages, and this is important for the analysis. The first stage is to do a threshold analysis. The investigator is going to speak to the complainant, look at the allegations, and assess whether, if true, they would meet the definition of discrimination and thus warrant further investigation. And then if it meets threshold, the retainer also says that the investigator will conduct the investigation itself. There is a meeting with the complainant on June 27th, and then on July 13th, the investigator advises the complainant that their complaint has passed threshold. At this point, the investigator has also prepared a statement of investigations, which for many of the investigators on this call, that's something we do, right? If you don't get a written complaint, what you do during your first meeting with the complainant is go through and confirm that you have a full list of their allegations, so you're not engaging in scope creep. So you know exactly what it is that you're looking into, and you're confirming with them that you are fully understanding and fully including the issues that they are complaining about. Between July 13th and August 30th, the case law is silent. And then August 30th, the griever gets notice from TMU that there has been a complaint and a copy of the allegations, and that then an investigation will follow. That's a big break. And I appreciate that it's a university, and so you're probably giving people their summer break. But my concern here is that the human brain is finite. Like the capacity to remember is finite. Just ask me what I had for breakfast this morning. It's going to take me a good 30 seconds before I answer tea, because that's what I have every morning. But I have concerns about waiting until August, when the complaint came in, until March to let the person know. And I'm surprised this actually wasn't raised by the faculty association, who probably just appreciated this person was allowed to have his vacation in full. And then they are contacted, the respondent is contacted by the investigator on September 6th. And then the faculty association jumps in on the 8th, raising concerns about the fact that the investigator is actually somebody who was involved at an earlier stage. There's some back and forth, and ultimately TMU says, we hear you, but we disagree, and this person is going to be proceeding with the investigation. That's investigation 1. Investigation two. In late December, early January of 2022-2023, a complaint comes in from two members of a department at the university. Alleging, goodness, what are they alleging? I can't remember if it was harassment or discrimination. There's a complaint, and then discussions happen with the investigator who is retained on February 16th. So again, we're going from late December, early January to February 16th for a retainer. The 28th of February, the complainants withdraw. They decide they're not going to proceed with their complaint. Then another interesting timing piece. On March 6th, there's a meeting between the investigator and the university because the university has decided to run a university-led investigation and they want the investigator's assistance with that. And on the same day, 6 other members of the same department that the two people who had made the previous complaint about meet with the university and give their version of events to back it up. So there's going to be a university-led investigation with the assistance of an investigator. A revised retainer is provided on March 13th to reflect the fact that it's going to be a university-led, institution-led investigation. And the investigator proceeds in the following months to meet with the respondents, the complainants, identify 2 potential other witnesses, meet with those witnesses who are ultimately deemed not to be relevant to the initial issues, and so not going to be proceeding with them, and to prepare a draft statement of issues, statement of complaints, allegations. Again, this happens in around June, and then the griever, the respondent, doesn't get notice until August 29th. So it looks like it's a pattern here. We're waiting for the summer. So for workplace investigators who are dealing with employees who don't work for particular times of year, just something to think about that isn't addressed in the decision. Do you wait or do you prioritize memory capacity when you're looking at when to notify people? So when all of this happens, they get the same objections, September, October, November, from the Faculty Association to the fact that the investigator on that one, which is a different investigator, but from the same firm, was involved at an earlier stage, and therefore there are allegations that the person's biased. Next slide, please. So there's a great summary in the decision about what procedurally fair independent investigations require. I highly recommend people read it. The retainer, so the Faculty Association took issue with a number of things. One is the type of retainer agreement, which they say created a solicitor-client relationship, which is antithetical to a neutral and unbiased investigator's ability to investigate. Whether it's appropriate to have an investigator both prepare a statement of allegations and then conduct the investigation, whether that it's appropriate to have an investigator conduct the threshold analysis and then conduct the investigation, and the kinds of discussions that should be occurring between an investigator, an independent investigator, and the institution that's hiring them. The spoiler alert, the issue raised with the retainer was deemed to be founded. It referenced a legal services relationship. It talked about rendering reports as legal counsel to the university rather than as an independent investigator. And there was language in the retainer about the rules of professional conduct and what happens if there's a conflict that arises, and that the investigator would have to stop acting as their counsel in the event of a conflict, which are all things that are antithetical, again, to a neutral independent investigator. Next slide, please. So here are the things that are discussed in detail in the very interesting decision about conflicts between an obligation as counsel and an obligation as an investigator. So the duty of loyalty piece, where you have a duty to loyally advance the interests of your client, as opposed to a statutory duty to investigate, the duty of candor. And there's a lot of discussion about this, about a duty of candor means you have to let your client know everything that they feel they need to know in order to fully defend themselves and act with response to. There's better discussions of this in all of the rules of professional conduct across Canada, but essentially it's the duty of letting your client know things as they become, that are relevant to them and matter as they arise, as opposed to the confidentiality considerations that apply to a number of workplace investigations. And for those of you who, like me, have investigated a number of sexual assault matters, the confidentiality piece can be really pressing and really impact the way you manage a file. And if those conflict, then how are you gonna handle it? The duty to act in accordance with the client's instructions. So in my retainer, I actually say that I'm a neutral third party and it's important that my independence remain intact. And that's exemplified here in the conflict between the duty to act in accordance with the instructions of the person who's retained you and is instructing you, and the obligation to remain independent in how you conduct an investigation and analyze the evidence, et cetera, et cetera. And then obviously as an advocate, as a lawyer, you're an advocate, and as investigator, you're supposed to remain neutral. Next slide, please. So the duty of loyalty, which we've previously discussed, includes the duty of zealous representation and to put the client's interests before all others. And the client's interests are not necessarily the same interests as those of a neutral third-party investigation. Their interests include avoiding legal liability, suppressing or downplaying certain adverse facts, and reputational interests. When you're doing a neutral third-party investigation, there may be things, maybe findings that come about that don't reflect well necessarily on a whole as a particular workplace. And so if you've got to deal with those interests and prioritize those of your ability to act as a neutral third-party investigator, that can complicate things. Next slide, please. This is important, and I'm sure that anybody who wasn't already familiar with this decision was on tenterhooks about this. There was no issue with the lawyer acting as an investigator, period. There was no issue with a lawyer conducting an initial analysis, the threshold analysis. And it was actually compared with a judge's role in making a finding at the outset of trial about whether a prima facie case had been made out. And the fact that it's fine to make this, just because you're saying that they would constitute XYZ if true, doesn't mean that you're predetermining that they are in fact true. And it's fine to prepare a statement of allegations. And as many of you know, we do this all the time. The first thing you do is you confirm the scope of the investigation based on confirming the actual details of the allegations. Next slide, please. The Quebec arbitral decision, I am very close to it time, but basically the moral of this decision is don't mess it up. This decision involved an anonymous complaint against a leadership team, and then based on assumptions, without any backup, the decision was made that the complaint was actually against a particular individual. That individual was not given details of the complaint until 2 months into the investigation, and even then the person had conducted 2 interviews. They were isolated from the remainder of the individuals that they worked with. It was found to constitute psychological harassment. Next slide, please. Now, for those of you, pour ceux qui sont en Québec, on comprend pourquoi c'est important. For everybody in Quebec, we know why this is important. For the rest of Canada, I want you to look at the definition of psychological harassment for a second, which is up here on the slide, and see if it looks familiar to you. Because to me, this looks an awful lot like the definition of harassment that applies almost every other place in Canada, or at least every place where a definition of harassment exists in the legislation. So it's a fine line. It's not hard to imagine that the finding of psychological harassment based on an improperly performed investigation could transfer over, should the facts allow it, in any other province or territory in Canada. And with that, I will wrap it up. If anybody has questions, please let us know. Oh, actually, if you want to go to my last slide, please. The summary is the basics of procedural fairness remain unchanged. They're summarized beautifully in the TMU decision. For third-party investigators, it is a good idea. I mean, they should be, retained as independent investigators and not as legal counsel because of the conflicts between the two roles. For those of you who are conducting investigations internally, you're fine as long as you're unbiased and not involved in the investigation, the allegations being alleged, and as long as it's not involving a senior member of your organization, because then you can't win, because it's going to be alleged the allegations of bias irrespective. And it remains the employer's obligation to make sure that everyone's rights are respected, including those of alleged harassers. And now we're going to move over to a question and answer period. Shout out to Danny Shaw. I love that you love Law and Order SVU as well. We're gonna bond. In the meantime, let's throw a question to Cristina. What happens to privilege if the investigation has both a privileged and non-privileged component? Does the privilege win?
Thanks, Stephanie. I just before I do that, I also love Law and Order SVU and have been watching it forever. So if you have kind of a combination purpose, so again, remember that there's the two different types of privileges. So analyze it on both. And so for the litigation privilege, you have to look at what is the dominant purpose. So you may not win on the privilege issue on that part if the non-privileged purpose is considered the dominant purpose as opposed to the privileged purpose. But you may still be able to argue that it's subject to solicitor-client privilege. And again, it depends on how you've set up the purposes, how you've set up the investigation. But if there's a bit of a combination in the elements, then arguably the solicitor-client privilege would win out on that one.
Helps to have the audio at hand. As a follow-up, does the privilege determination mean that a judge will consider the investigation report when it becomes evidence at trial?
No, not necessarily. So the privilege, so in the case I talked about, the question was production. So the plaintiff wanted to have access to the documents as part of the parties' obligations to disclose their relevant and material documents. The question of admissibility is a different issue. And if it's strictly a question of, well, was the plaintiff wrongfully dismissed? Did the defendant have just cause? Then typically the court's going to say, I don't care what your investigator determined. I need to make that decision. So in a lot of instances, the court's going to say that the investigation report isn't admissible because it's not relevant. So the court needs to make their own determination about just cause. The fact that an investigator determined well, about just cause and the facts leading up to that. So ultimately that fact finding, that's up to the judge. So the fact that an investigator may have found that it was or was not harassment is not going to be something the judge will necessarily admit. Now, if there's questions about, was the investigation done unfairly or in bad faith, or was there gaps, then you can see in those instances, then the investigation report and materials may be admissible in evidence, because then that's a live issue that the court has to determine.
Thank you, Cristina. There's one last question, even though we have 1 minute left. I really want to squeeze this one in because it's a compelling question. How to handle scope creep when an employee continues to raise allegations throughout an investigation. So for me, it comes down to whether or not those allegations, if true, would meet the definitions of the particular items. As an external investigator, I have a particular scope. So if there are allegations that are being made that I think the employer needs to know about, I will forward them and indicate whether or not I'm recommending a further investigation and seek instructions whether or not I'm to expand my scope. But I don't do it without instruction. Internally, it's going to come down to an assessment of whether those allegations meet the definition of harassment. Sometimes those allegations are actually allegations related to the reasonable use of managerial authority, in which case you wouldn't. But if somebody is actually raising something where there is a duty to investigate, either statutorily under the Human Rights Code or the relevant occupational health and safety legislation, that's probably something you're going to want to look into. And with that, I would like to thank our speakers and to everyone who joined us today. And we hope you found the session valuable. Thank you very much.